All right, thank you. Thank you, Cosmos. Esbon, I don't know if you are in. Esbon and I will be taking you through this paper. I don't know if Victoria McKenna, are you in? All right. So now, guys, this was a reasonable paper. Okay, that is my view. So I hope we are going to participate, give our ideas, considering the exams are around the corner. So maybe I can first ask someone to maybe pray for us. Donna Odwor, please pray.
Good evening. So let's pray. Thank you, Lord, for this day. Thank you for bringing us this far. Can we
We cannot hear you, Donna. It seems she's having challenges. Let me hold her brief. Our Heavenly Father, thank you for today. Thank you for these students who are about to do the exams. I pray that you give them wisdom, you give them understanding, you give them knowledge so that they can appreciate and understand everything that they are reading. I pray that you give them 9 peace so that they can pass the exams and begin their lives further. As we pray shortly, as we believe, amen. Somebody to say amen. Donna, I have heard your brief.
Amen.
Yes, I am not a prayer warrior.
Sorry, I lost my connection a bit.
No problem. In the meantime, maybe you can read question 1 for us if you are back.
My screen is still blank. I've just connected to another network. I can't see the question from my side.
Okay. Cosmos, you can. Okay, thank you, Otieno, Juline. Please proceed. Soma Swal.
So question 1, Greenwood Salah was charged alongside 3 others in Nakuru Chief Magistrate Court with the offense of obtaining by false pretenses contrary to section 313 of the Penal Code. The particulars of the charges were that they accused jointly with others with intent to defraud obtained from Mikel Arteta 3 million USD by falsely pretending that they had won a tender to supply sugar to food miners and K5 supermarkets in Nakuru, respectively, a fact they knew to be false. All the 3 accused persons pleaded not guilty. The prosecution counsel called 6 witnesses and closed its case. The chief magistrate found that a prima facie case had been established. The accused were placed on their defense. When giving his evidence under oath, Greenwood indicated that he had valid local purchase orders for supplying sugar from food miners and K5 supermarkets, which were in custody of the investigating officer in a related case now before the Molo Principal Magistrate Court. During cross-examination, Greenwood insisted that he was aware of the existence of the LPOs. At this point, the prosecution counsel applied to have the witness, into brackets, accused person. It has gone blank, green. Oh, yes. Okay. So at this point, the prosecution counsel applied to have the witness, accused person, stood down and given time to obtain and present the LPOs before the court. The defense counsel objected to this request, citing several provisions of law. The CM overruled the objections and formally allowed the application by the prosecution on 4th November 2021. During subsequent hearings, Greenwood was unable to present the LPOs, at which point the prosecution counsel applied to call 3 more witnesses from Food Miners and Car5 supermarkets. The prosecution counsel now sought to rebut the assertion by the defense on the existence of the LPOs, arguing that this went to the substratum of prosecution case. Since the case theory was that the accused person had obtained 3 million USD from the complainant in the alleged guise that they had genuine LPO, the prosecution counsel further insisted that they were now required to prove the contrary. The defense counsel objected to the request by the prosecution to allow additional evidence at the stage of trial. Yes, the CM rejected the objection and allowed the request by the prosecution. As fate would have it, the CM was appointed a judge of the High Court before the matter was listed for hearing on 15th December 2021. The principal magistrate, (PM), took over the proceedings. The defense counsel requested for a new trial, but the prosecution objected, citing that some of the witnesses who had testified were no longer available. The PM agrees with the prosecution, at which point the defense counsel takes the contention to the High Court in Nakuru under the relevant procedure. You were recently appointed as research assistant to the presiding judge in Nakuru High Court. In Nakuru High Court, before whom the case file is now placed. The judge calls you into his chambers for a discussion about this case. With the aid of decided cases and statutory provisions, A, evaluate the appropriate jurisdiction under which the judge may be required to adjudicate this matter. B, anticipating the arguments that might have been raised by the defense counsel, examine the legality and regularity of the order made by the CM on 4th November 2021. 5 marks. C, analyze whether the ruling on 15th December 2021, allowing the prosecution to call 3 additional witnesses, was regular. D, under these circumstances, is Greenwood Salah entitled to a new trial? Explain your answer. Yeah.
Very good. Thank you so much, Juline, for reading the question so well. So guys, this is the question, and obviously it is 20 marks. So, and they have been spread across 5 marks, 5 marks, 5 marks. So I would like maybe in 2 or 3 minutes or so, maybe someone can analyze the question for the members. And anyone who has understood this question, someone, please. Maybe before we tackle question number 5, what do you think this question is testing? And what have you understood that the examiner wants us to do in this matter? Anyone, you can raise your hand. There are 38 of us. I'm just here to guide where necessary. The revision is among ourselves. Anyone, please, you can raise your hand. I am waiting. Evaluate the appropriate jurisdiction under which the judge may be required to adjudicate this matter. 5 marks. Anticipating the arguments that might have been raised by the defense counsel, examine the legality and regularity of the order made by the CM on 4th November 2021. 5 marks. Analyze whether the ruling of 15th December 2021, allowing the prosecution to call 3 additional witnesses, was regular. Under these circumstances, is Greenwood Salah entitled to a new trial? Explain your answer. So guys, Hello, gentlemen and gentlewomen, or ladies. Hey, am I alone? Hello, guys. I'm still waiting. Okay, Julian, sorry, Julian. Maybe take us through question number A.
Oh gosh, I don't know. Okay, I think there's a hand. There's a hand raised. Julie, I think you can proceed. Julie, yeah. Proceed.
Okay, Julie Atieno.
Okay, hello. Can you hear me?
Yes, we can hear you loud and clear.
Okay, my network is a bit shaky tonight, but I'll give it a shot. From my analysis of question 1, I think the main issue comes from the prosecution. What happens after the prosecution closes its case? Because when now new evidence suffices that they realized was not within their ambit, like what is the procedure that ought to be followed? And generally when after the prosecution closes its case and they realize from the defense's testimony that there is some new evidence that has popped up, can they go back and say that we'd wish to call more witnesses or to go back to the drawing board? I think that's what I saw. And also the issue of, oh my God, my network, Christ.
Thank you, Julie. Oh, you are still there?
Okay. Hii network itanisumbua hivi kichwa.
But we can hear you.
Yes, my network is shaky today, but the last thing I was about to say was in relation to the new, yes, in relation to the new trial that the defense counsel had requested that, yes, now that I don't know how to phrase that, but those are some of the key issues that I see in this case.
All right. Thank you for your contribution. I can see Odur Donna. Yes, please proceed. You can unmute.
Okay, from my understanding, this question revolves around revision, the revision jurisdiction of the High Court, because we've been told that they went to the presiding judge in Nakuru to decide that matter. And this paper, okay, we tried discussing, but the question kuna venye ilikuwa ngumu, so someone referred us to the case of Stephen Buru Kinyua versus Republic, which apparently has similar facts to this question. However, I am yet to read the case, but we were told it's similar facts and it concerns revision jurisdiction of the High Court.
Okay, thank you. I agree. Let's say on the first question, that is question A, it is testing on revision. But can you please proceed and maybe tell us what are these provisions of the law under which the judge now can maybe say that he or she has jurisdiction to maybe entertain this particular application that has been filed before him or her? What is the provision of the law?
Okay. Provision of the law, we have Article 165 of the Constitution, which gives, I think it's 165, which gives the High Court the supervisory jurisdiction, and under this revision is one of them. And then under the Criminal Procedure Code, it is section 362. And in both, the judge can exercise its the High Court can exercise its supervisory jurisdiction where there was a mistake, illegality, when a trial was conducted, and revision can be undertaken either when the trial is going on or after its conclusion. Yeah.
Okay, thank you, Donna. Anyone who can tell us the elements? I note that Donna has mentioned some, or maybe she meant something else. I don't know, but she has mentioned a few here and there. What must be met for you to make this particular application or this revision application? Because here we are talking about 5 marks, okay? So you have to tell us what is that was missing, or the challenge that was there that made this person to apply to High Court for revision. Section 362 was mentioned. Is that the only section though? Maybe someone can guide us in matters revision. Anyone else, please? Apart from Donna or Julia? Anyone else? You can raise your hand, please. Are we back again to keeping quiet? Ladies and gentlemen. Yes, Julia, your hand is up. You can proceed. Hiya guys, I don't know what is wrong, because I'm not going to revise the whole paper myself. Anyona Oscar, please unmute, proceed.
Yes, good evening, Senior. I hope you can hear me.
Yes, I can hear you, sir.
Yes, just to comment a bit on revision under section 362 of the CPC. I'm having trouble locating my CPC, but I think I can just proceed. So it says that you can invoke those powers of the High Court for revision against, well, if you feel that a subordinate court has made a mistake during proceedings. So revision lies against or with regard to the correctness, propriety, or legality of an order or procedure at the subordinate court. So in this case, going by the facts that we've been given, there's an order that the subordinate court made dismissing the request or the application by the defense to have a new trial because of an availability of witnesses. So because that order then, because of that order, whoever went to the High Court in Nakuru felt that that order was made, that the order was made was not incorrect, and therefore that's the way that he can approach the High Court. So I think that may help.
Okay, thank you, Anyona, for your contribution. So I commend Anyona, Odur, and Julia for their contribution. Indeed, question number A was testing about criminal revision, okay, which is anchored under section 362 of the Criminal Procedure Code. So when I was talking about the elements, because something must happen, you see, when we are talking about civil procedure, and sometimes people do mix this, we have something called review, okay, whereby someone will say review and revision are opposite of the other, in the sense that review is in civil litigation, whereas revision is in criminal litigation. Okay, I agree that is the case. But the difference is, you see, review, you are applying to the same judicial officer. It can be the magistrate or the judge. But here, revision, it is only jurisdiction that is given to the High Court of Kenya. Okay, it is that supervisory jurisdiction. Okay, whereby the High Court may call for and examine the record of any criminal proceedings before any subordinate court for the purpose of satisfying itself as to the correctness, legality, or propriety of any finding, sentence, or order recorded or passed, and as to the regularity of any proceeding of any such subordinate court. Do we think the way that the magistrate conducted himself or herself, was it in order, considering the prosecution closed, okay, his or her case? I don't know what happened in between there. They applied, okay, that certain documents be provided. They then proceeded to call some witnesses. Then now it was like a shamble whereby they are gambling on some kind of evidence to be tendered before the court. Even if you want to adduce, let's say, new evidence, do you do it that way, or there are certain elements that must be met before you proceed that way? Several elements are being provided by the Supreme Court in that respect when you want to adduce new, or let's say something called additional evidence. Okay, so here the other section that I wanted you to bring out is section 364(1)(a) of the Criminal Procedure, which provides that in any case of a proceeding in a subordinate court, the record of which has been called for, or which has been reported for orders, or which otherwise come to its knowledge, the High Court may, in the case of a conviction, exercise any powers conferred on it as a court of appeal by section 354, 357, and 358. and may enhance the sentence. Okay, so it is really not like a clear cut when you are talking about revision, because there are other two things that are also, some people will say that they are similar to this. We have something called new trial. Okay, we have another one called retrial. Those are two different things. Okay, I hope you guys are appreciating your, is it called bench book? Yeah, because those things have been stated there very clearly and the circumstances are different. Okay, so that is it on that particular question number A. Unless if someone has a question, maybe you all can try to read the case that was mentioned by Odur. Okay, Anyona, is your hand up?
Sorry, it's not supposed to be. It's such a low.
Okay. Thank you. So guys, that is my view on question number A, considering that it is only 5 marks. So maybe someone can read for us question number B. Maybe we try to also get answers to that particular question number B. Cosmos, please read for us.
Anticipating the arguments that might have been raised by the defense counsel, examine the legality and regularity of the order made by the CM on 4th November 2021.
Thank you. Would you like to guide us on that question, Cosmos?
I would like to cede the floor to my colleagues as well. I'm trying to get forth.
I will invite them.
Yeah, I've reached paragraph for 4th November.
Okay.
Yeah.
So guys, we are in question number B. Anyone? Anyone, guys? Let us do this. This is just a 5 marks question. Guys, I'm waiting. I'm still waiting. What are these arguments, by the way, the defense is making? Anyone, please? Yes, Mwangi Samuel, thank you. Proceed.
Okay, I think that in this case, the order made by the CM was not legal and regular, and this the defense in this case might have raised the defense that they were not supposed to produce any evidence that would be self-incriminating pursuant to Article 52L of the Constitution. So it was up for the prosecution to prove their case beyond reasonable doubt. The defense was not supposed to produce anything to defend themselves.
Thank you, Mwangi Samuel. I was trying to reach my colleague. Anyone else on that question? Guys.
Hi everyone. Hi Angelo.
Hi, Gitari.
I was joined in and I've just been following, and I don't know. Maybe is it that you guys have not done revision at the topic, not revision like revising, but criminal revision, because I find that the audience is awfully quiet. So Angelo, I don't know, maybe if you can try going to, it's just a suggestion, if it would be better to go to another question whereby people are a bit active, because I feel like that saves on time. Or rather, if you people have questions or answers, you can participate, because it really saves on time in terms of doing discussions when people are active and are participating, rather than when the course coordinator has to keep asking anyone. It takes a lot of time, and you might end up spending up to 11 while you've just covered something small, and by the time you are reaching to questions that people are conversant with, you are already tired. So my suggestion is at least maybe we can try to participate, and if not, you can hold the question and move to another question. That's just my suggestion on the observation of how the session is going.
All right. Thank you, Gitari, for that input. I think we can go to the next question and to see if maybe the question was the problem. Because I remember last time when we were revising this paper, we were really jovial. Everyone was ready to put out their point there. I don't know what is happening, because you are one of the group that can really participate. But today you are, I don't know, you are really quiet. I don't understand if it is the question that is the issue. But in any case, we can go to the next question. Hopefully you will participate. But if not, then we will see how we can proceed from there, because maybe our head is focusing on CLE, because the numbers can even tell. So we can go to the next question. Cosmos, we can see the paper.
Yeah, there seems to be something. Let me stop sharing, then share again. Okay, 1 second. Okay. If somebody else has access to the paper, please share screen. For some reason, the paper has refused to load. I hadn't downloaded it.
I cannot share on my end. I have never understood why. Okay, I can see the question there. Yeah, that is better. All right, you can scroll down. Guys, I'm going to read the question. Adamu Mwongozo, a resident of Babandogo in Nairobi, was arrested by the police officers on 29 September 2021 at his house and in the presence of his wife, Gwenzori Zawadi. He was bundled into a waiting police van and driven away. Ruwenzori Zawadi was informed by an identified officer that Adamu was being taken to Pangani police station on orders of the Inspector General of Police for interrogation on his suspected involvement with the terrorist group locally known as Musahideen. Efforts by Ruwenzori to accompany Adamu to the police station at the point of his arrest were thwarted by the police, who informed her that instead she will be contacted by the Officer Commanding Station OCS Pangani Police Station. On 30th September 2021, Ruwenzori, accompanied by other family members, visited Pangani Police Station, where they were shocked to learn that Adamu had not been booked at the station and further that the OCS had no knowledge of his arrest and or detention. To date, Adamu's family are in the dark as to his whereabouts, despite frantic efforts to visit several police stations in Nairobi, including searching for his body at the city mortuary. Ruwenzori Zawadi believes that Adamu is alive and in police custody, and as a result, she has made several pleas to the Inspector General of Police to either have Adamu charged in court or released unconditionally, but there has been no response. Haki Africa, a well-known human rights NGO, has approached you as an advocate to file the necessary application on behalf of Ruwenzori Zawadi challenging Adamu's arrest and detention. Draft the application. 10 marks. So guys, that is question number 2. I have read it as slow as possible. Hopefully you are following. So maybe we can have the first person try to maybe virtually or maybe theoretically draft for us that particular application and maybe state that particular application. What is that particular application that we are going to draft? Thank you. You can raise your hand. So anyone, we are in question number 2. Yes, Julie Atieno, proceed.
Okay, I think question number 2 relates to an application of habeas corpus, because we've been told he was arrested and he's not been taken to court, and they still do not know where he is, and efforts to reach out to the Inspector General have been futile. So habeas is, according to me, is the right application, because habeas generally is produce a body. So in this case, we will be compelling the Inspector General to produce what is his name? Adamu Mwongozo. And for the specific application, I'd say chamber summons and is it a supporting affidavit? I'm not so sure about whether we're supposed to put a certificate of urgency, but I can let the rest give also their views on that. But I feel like it's habeas using chamber summons and supporting affidavit.
Okay, thank you, Julie, for that wonderful contribution. Please let us clap for her. Makofi. Thank you. Rogers, tafadhali proceed, Honorable. Then Donna will follow. Rogers. Rogers, your hand was up. Okay. Donna, in the meantime, you can proceed and mute.
Okay, as Julie has rightly stated, it is an application for habeas corpus. So we'll need a certificate of urgency because this is a person who is being detained and his whereabouts are unknown. So you have to seek that the court moves with speed. So in drafting the relevant documents, so the certificate of urgency, obviously there'll be the caption Republic of Kenya, and then the jurisdiction is the High Court. So in the High Court at Nairobi, it is a miscellaneous criminal application. The applicant, I'm not sure if we're supposed to have Adamu or Haki Africa or Rwenzori, but okay, maybe I can have Adamu and Rwenzori, we were told that way, versus the Inspector General of Police Station, and maybe the OCS Pangani as the respondent, and then certificate of urgency, I so-and-so, an advocate of the High Court of Kenya, do certify this application as urgent, and then you give the reason, the fact that he's being detained and he stands to suffer, or maybe he's being tortured, and then dated at Nairobi this dash day. Then you sign off. And then the chamber summons caption will be similar to the certificate of urgency. And then I'll make the application under Article 51 of the Constitution, Section 389 of the Criminal Procedure Code, and then the rules of habeas corpus. And in the prayers in the chamber summons, so the first obviously will be that the application be certified as urgent, and then the second that the court to issue directions in the nature of habeas corpus, so that the first and second respondents to produce Damu before the court. And then, yeah, I think those prayers, and then the grounds will be just a short story of what transpired, and then the supporting affidavit will basically give an account of everything that happened up to his arrest. And this supporting affidavit can be sworn by the wife, Rwenzori. Yeah.
Okay, thank you so much, Odur Donna, for that wonderful contribution. Tafadhali, again, let us clap for her. Piga makofi tafadhali. Asanteni sana. Very good. Asanteni sana. So that was really great. Donna, you have basically taken us through the application. I don't know if there is someone else who has something else to add to that. Anyone? Because I think the two members have really tried. Anyona, Oscar, please proceed.
Well, yes, not necessarily an addition. My sister Donna said everything I would have wanted to say, but I have a question.
Yes.
Now, with regard to the applicant, because the one who has been abducted is called Adamu, I think from the question, and then the wife is Rwenzori Zawadi. So who is supposed to be the applicant, and then that will inform who swears the affidavit. So we want to educate us on that because Adam is not present to swear the affidavit.
Thank you for that question. It is a great question indeed. And Kiplimo Cynthia, should I answer this question or yes? Proceed. I will answer.
Okay, can you hear me?
Yes, I can hear you.
Okay, so it's the wife who will apply on behalf of Adamu, that is Rwenzori Zawadi, who is the applicant in this matter on behalf of Adamu. So she's the one who will be the applicant, and she's the one who will swear the affidavit. So yeah, because according to what I drafted in class, my caption read, in the matter of application by Rwenzori Zawadi on behalf of Adamu Zawadi, and in the application for orders of habeas corpus. So she's the one who will swear the affidavit on behalf of Adamu, the husband.
Okay, thank you for that contribution, Cynthia. Indeed, it can be the wife who can be the applicant. It can equally be Adamu who can be the applicant. It is called an ex parte chamber summons. So guys, you can go with any. In the examinations, I use the wife. I also have colleagues of mine who use the person that was abducted. So I don't think if there's an issue there, even when it now comes to the affidavit, the wife can swear that affidavit in support of the application in her capacity as the wife. So Adamu in the circumstances is an ex parte applicant, okay? But the affidavit in support of the application can be sworn, yes, by the wife, okay? Or if you want, because I understand maybe you have listened to one Jackton, or is it Jackton, and he was saying that how is this person going to swear an affidavit in his absentia, okay? That was his argument, but if you look at most books or maybe most applications that have been drafted of this nature, you will realize that it is actually the accused person or the person who is detained is the one who is the applicant. I don't know, Gitari, you can respond before I conclude on this question, especially on the aspect of who is the applicant or who is supposed to be the applicant. Makena, are you there?
Yes, Angelo. Sorry, I have not gotten the names, but I can't see the question on the screen.
Yeah.
But I believe the said question was talking about an habeas corpus application, and so obviously, since the person that, let me open that question so that I can get the names correct. But essentially, the person who's already in custody cannot be the applicant, because now you see, can be the applicant, but mostly the person who will be the applicant is the wife. Sorry, I was opening that question. Okay. It is okay. Yeah. All right. So the wife is Zawadi. So I think Zawadi will be the applicant essentially, because she's the one, she can swear the affidavit on behalf of the person who's in custody. That was the thing in contention, Angelo?
Yes, that was the thing in contention.
Yeah, so the wife can be the applicant, and then I don't know if you've discussed where the application will be made. The court, is it the High Court?
Yes, the court is
that can also. Yeah.
All right. Thank you, Gitari. So, like Gitari, I believe our applicant in the matter was the wife. Mine at the same time was the wife, but I also know of the people or even the books whereby the applicant is the person who is detained or who is arrested. Yes, Donna?
I have a question. What is the import of having Haki Africa in this question, where we are told that they approached you to file the necessary application on behalf of Rwenzori?
The import of Aki Africa, you see, this is what they do, okay? So they are just like, I don't know what to call them, because they are not advocates, but you see, they are now giving you instructions, because these are human rights defenders, okay? But in the circumstances, they will not be the applicant. So you see, maybe the wife does not have the resources or things like that, okay? So they don't actually have nexus with the accused or the arrested person. However, if you look at is it article 22, actually they can file the application, but I think we will be overstretching, because you see now any person can actually file a suit, but most of the time a constitutional petition on his or her own behalf or on behalf of others. But in this case, they are just like a group or something like that. Yes, someone is unmuted. Mind your privacy. Please mute.
Mr. McCoy, you can unmute and proceed. I think I muted everybody because of the disturbance. Sorry.
Okay. Thank you, Anyola. Thank you, Anyola. So you see, that is how it is. You can, I believe it can be safe for you to use the wife as the applicant, but it is, I don't think it is entirely wrong for you also to use the husband or the person arrested. Okay, that, because that is what I did, and I maybe I got maybe reasonable marks. I had crammed it well at the time. So maybe if not 11 out of 10, maybe 10. Okay. But guys, the application is filed in the High Court. So your caption will read the Republic of Kenya in the High Court of Kenya at Nairobi, miscellaneous course number this one. So you can now talk, state like in the matter of Criminal Procedure Code, section 389, and in the matter of the Constitution of Kenya, Article 50, is it 51.2? Article 51.2, okay? And in the matter of the application for direction in the nature of habeas corpus, and in the matter of criminal procedure, directions in the nature of habeas corpus rules, then now you can put the wife as the applicant and the Inspector General of Police as the respondent. So you realize you will have your ex parte chamber summons. Then how are you moving the court now? So it is under Article 25D and Article 51.2 of the Constitution of Kenya, 2010, Section 389 of the Criminal Procedure Code, and Rule 2 and 3 of the rules in the nature of directions of habeas corpus. So here also you are being tested. How are you going to begin that particular document? Remember, it is a chamber summons, okay? So you will not say, take notice that, or let so and so. This one you will say, let all parties concerned attend the honorable judge in chambers. So you know how the chamber summon is supposed to be, okay? But here you see the orders you will seek will not change. Most of the time they are 5, okay? Whereby the first one is that this application be certified as urgent and service be dispensed with in the first instance. Then number 2, very crucial, is that an order, the directions in the nature of habeas corpus do issue directed to the respondent and or his agents and or representative to have the body of Adamu Mongozo produced before the honorable court at such time as the judge may direct. Number 3, that an order that the respondent and or his agents to appear in person or by his duly authorized agent together with the original of any warrant of arrest or order of detention to show cause why the said Adamu Mongozo should not be released. Then second last should be that pending the hearing of these summons inter partes, the respondent be directed to release the applicant on bail on such terms and conditions as the court may deem fit to grant. Then finally, it is that order on the issue of cause. Okay, so most of the time you will be needed to master those three orders, that is order number 2, 3, and 4, because they form part of your substantive orders. So as Donna stated before, the grounds will be like you are now narrating the story, okay, of the matter. And don't forget the application is under certificate of urgency, okay? So the supporting affidavit, of course, will be sworn, okay, by the wife, okay? She will be the one to swear the supporting affidavit. So unless if anyone asks a question, we can proceed to question number 3. Any question, guys? Yes, Honorable Anyona.
A very quick one.
Yes.
We have talked about the applicant. I'm not sure if we talked also about the respondent in this case, because I had my sister, is it Donna, suggest that we can have the respondent as the OCS, but I've seen applications of this nature where the respondents are the AG, the Honorable AG, and the DPP and the Inspector General of Police. So we also want to educate us on that.
Thank you. Yeah, the reading of the question, the proper respondent in this matter will be the Inspector General of Police, okay? The OCS is acting under the Inspector General of Police. So you cannot sue the Inspector General of Police and sue the OCS, okay, at the same time. So the proper respondent in this matter, especially for this question, is the Inspector General of Police, okay? Because here I have not seen anywhere something that connect the DPP here. Although, like the application that we drafted in our examinations, it was brought out clearly, and we joined the DPP as the second respondent, or was he the first respondent? I don't know. But the proper respondents in applications of this nature are the Inspector General of Police, the DPP. On the aspect of the Attorney General, not so much, because you see the Attorney General now has different role altogether. So this is something that fall within the ambits of the DPP. So applications of this nature, the proper respondents are the Inspector General of Police and the Director of Public Prosecution. I don't know if I have answered you, at least for purposes of...
You did, and thank you for that.
Yes, at least for purposes
of...
Yes. So out here, a lot of things do happen. So in the meantime, we can focus on the syllabus, because maybe some examiner may think otherwise if you joined the Attorney General, the Honorable, the Attorney General as one of the respondents.
I had a question.
Yes, please proceed.
In the same question that you're answering, you said that there were 3 applications that we must master them. I didn't quite hear that part.
I mean, I said 3 orders.
3 orders?
Yeah, 3 substantive orders. So your order, even sometimes if someone has, would say that you have copied from each other, because they have to be identical. Maybe the words will change here and there. But the second order will be directed to the respondents, if they are 2 or respondent, or their agents or their representative, to produce the body. So the first substantive order, you see the first one is on the aspect of certification of the application, and the last order is course, okay? So the first substantive, that is your order number 2, will be directed to the respondents to produce the body of the person they have detained. And in the question that we are handling, that will be Adamu Mwongozo.
Yes.
Okay. Then now,
Yes.
the second substantive order will equally
Yes.
be directed to the respondents, okay, to produce the original, okay, copy of any warrant or any detention order to show cause why that person should not be released. So you can talk about arrest warrant or detention order. So it has to be brought, because you see now in Kenya, things are very procedural. Even when Brian Mwenda was arrested, okay?
Yes.
Charges were there. He was presented to the court within 24 hours. So before the 2010 constitution, we had something called detention order. It was the minister in charge of security, okay, would just write that and there's nothing you can do. They will just disappear with that person and the court will not have jurisdiction. That is during Moi era. Okay, that is the second substantive order, the aspect of the arrest warrant or a copy of a detention order. Then finally, okay, is aspect of bail in accordance with the constitution. Bail.
Okay.
So you to the court that your client be granted bail on such term and conditions as the court may direct. So those are the 3 substantive orders that you will seek. The body be produced, the aspect of the arrest or end detention or warrant of arrest or end detention order, and finally on the issue of bail. So those are your 3 substantive orders.
Thank you very much.
You're welcome. Any other question, guys, such that we can go to question number 3? All right, Honorable Cosmos, I think that is it there. Let us now go to question number 3. Anyone who feel like he or she is blessed tonight, you can unmute and please read for us question number 3. It is a short one. Tafadhali. We are reading the question, guys. Anyone? Question number 3.
I may.
Yes, please proceed, Anyona.
Yes, question 3, I read. In Republic versus Lucas Onyango Wallo, 2021, Justice R.E. Abrili held. In the court's humble view, justice is better served in these kinds of cases if both parties, that is the victim and the accused person, get justice. The victim's justice in this case can only be served through a fair hearing and a fair trial, and witnesses are enabled to attend court to testify on the truth of what they know, saw, or heard. If the accused is likely to abscond, then the court will be doing an injustice to the victim of the offense if it releases him on bond only for him to make the trial impossible. End of quote. Citing relevant case law and statutory provision, evaluate the holding of Justice Abrili in light of emerging jurisprudence on bail and bond for 10 marks.
Sorry, guys, I was muted. This is one of the great questions, and maybe it is one that you can expect. You see, criminal litigation is straightforward, unless maybe CLE decide otherwise because our paper was not friendly. Hopefully yours will be. So this is really a great one. So maybe someone can just tell us something about this question. How do we answer this one? Guys, this is a quick one. We can use less than 10 minutes in this question. Because I know question 4 we may require some time. Anyone, guys? Anyone? Don't worry about the aspect of the emerging jurisprudence on the aspect of bail and bond. Okay? So you see, it is a constitutional right that you are entitled to bail and bond. But you see here, we are trying to balance here the aspect of the fair hearing and also the aspect of the victims. Okay? So there are circumstances under which maybe this particular right to bail can be denied. Okay? Can someone please take us through this question, maybe quickly, tafadhali? Mwangi, your hand is up. You can proceed. You can unmute and proceed.
It's for the question that I asked earlier before.
Oh, okay.
Let me put it down.
Okay. Guys, let us do this one. Do you guys want us to skip this one too? I thought we agreed that we would participate now in subsequent questions.
Angelo?
Yes, Cosmos.
Probably I could start the discussion and maybe my colleagues will jump in.
Yes, please.
Yeah, so I would begin by saying that an accused person being denied the possibility of bail is not to be looked at from a punitive perspective, in that it is meant to punish them, but rather at the end of the day, the courts are focused on one particular goal, achieving justice, which is hinged on, the whole aspect of truth finding. So when it comes to the accused, when it comes to matters of bail and bond, or the accused person, the main goal is to make sure that we have a certainty that, because this accused person still has the presumption of innocence being applied to them, we need to assure them that, we need a guarantee from them that in the event that we let them, in the event that we grant bail and bond to them, which is basically a surety, guaranteeing the court that there is utmost certainty that this person, when released, will appear in court when requested and demanded. Of course, the court will give notice and everybody will know of the particular dates that a person is supposed to be presented to court. And then the court would be looking at, would have to take into consideration the likelihood of attending the trial and surrendering to custody when required by the court, the possibility of the accused obstructing, causing an obstruction of justice in terms of tampering with witnesses as a result of being granted the bail, and the possibility also of an accused person committing similar offenses that they're actually being accused of in this particular scenario, or even those that are not related to the particular crime. And it needs to take into consideration, which will seem like a regurgitation, the nature of the offense, the severity of the punishment, the strength of the prosecution case, the character of the accused person, and what would I want to state it differently, the likelihood of interfering with witnesses upon being released on bail. So bail is not letting the individual go scot-free. It's just assuring the court that, okay, in the event that this accused person has been let go, on the date that they're expected to be presented in court, they will be present. When it comes to the considerations that the court would be looking into, especially because there was this the last sentence talks about absconding court. There is a case. When I stop sharing screen, I'll maybe type it in chat. George Kamau Nganga versus R. And basically it still discusses the same considerations that the court would have to take into consideration. I think up to there, I can let any of my colleagues jump in.
Okay. Thank you so much, Cosmos. Maybe we can clap for Cosmos, tafadhali. Thank you so much. Thank you for clapping. So you see, guys, I agree with all that he has said, and actually the question here is giving us answers because they want to know. We are trying to balance these two. Of course, the accused person. Now you can try to even discuss the legal basis of bail. Where is it anchored in the Constitution? We have provisions for the same in the criminal procedure. Okay. So thereafter, if you first have to admit that that is actually the correct position. And you see, when now they disappear or they don't attend court, now it becomes another issue altogether. You have now served justice on one end. The person may pattern like that right to bail in accordance with the Constitution. What about the victims now? Where is their justice? This person has disappeared. He has gone to Rwanda, whereby we don't have any extradition treaty. He cannot come back. Maybe our good friend would have gone there when he was asking for 48 hours, but he decided to stay in because, a certain politician in the Republic of Kenya. But that is not the issue. So how then do court now come in to ensure that there is justice for the victim and there's also justice for the accused? Then now this is whereby the circumstances under which bail can be denied come in. Just ignore what has been written here. I don't understand constitutional right or right to be presumed innocent until okay. Because the question is kind of straightforward. What are those circumstances? I will refer you to your bench book. The authorities are there. I like that book. It made criminal litigation easier for me, especially when I was doing my revision. If you don't have a copy, just go to Alex at the Kenya School of Law. You will just purchase one for like, I don't know if it is 180 or 300 shillings. Okay. I'm not advertising for him. That is the caveat. So guys, now maybe we can have one person give us what are those circumstances under which one can be denied bail. I can go first. Maybe the accused person is a flight risk. Okay, anyone? Faster. Chap, guys. There are about 9. Guys, there are about 9 of this thing. There are about 9 of them. All right. Thank you. Okay. Cosmos, you can take us to question number 4. Yes, Kiplimo, Cynthia. You can unmute.
Okay, I wanted to answer the question that you asked. Instances where bail may be denied is in cases of sexual offenses. Sexual offense.
Mm-hmm. Sexual offenses? Mm-hmm. Maybe not. Donna?
I think other instances where the accused may be denied bail or bond is where they are a flight risk. That's one. Number 2, where there is a possibility that they can interfere with the witnesses and the victims.
Mm-hmm.
And another instance will be where they have no known aboard, like hawajui hata chifu wa kwao, so no one can track him or her. And if okay, for the sake of national security, so this mostly applies to terrorism cases. You just can't release a terrorist.
Mm-hmm.
there because you never know where they may bomb next. Yeah.
Okay, thank you. We have to all agree that yes.
Okay, I don't know, maybe you're responding to that, but there's an response that I've had someone say that in sexual offenses you can't have bond. I don't know if they can expound on that, because I believe that's not an accurate position.
Yes, I had say maybe not, but Cynthia, I don't know. You see, in law, all answers are correct. Maybe you can back it up. Can
Okay,
unmute.
so to support my answer on that, you see, when now maybe a father or a relative defiles a child, the court may consider the maybe the mental health or the security of that minor. If you're a dad and you defile your child, how will you live with that child in that house? Because one, she's traumatized, and the second is that you as an accused person, you might threaten her to not say the truth, and maybe that will continue traumatizing her. And in case of maybe rape, a rape is something that it traumatizes someone. So when you release this person on bail or bond, there is also that insecurity of the victim, because you are going back to the same place to live with that victim. So yeah, that is my explanation. I don't know if I'm right.
Thank you for your explanation. You see now, if you now explain, I feel like I have been persuaded. I don't know, McKenna, what is your view? I can, if I was a judge, I think I am persuaded in the circumstances.
I think based on explanation relates to the circumstances on where one can be denied bail, but the explanations are on point, but I feel like the realization that it's only in sexual offenses that's what can make someone miss the point, because it can be a sexual offense, and an accused person can actually persuade the court that they will not, maybe threaten the witness. So it's not about the type of offense, but it's about the circumstances of a case. So in how she has explained it, it's perfect. But in generalizing in sexual offenses, that can mislead someone, because there are people who have been granted bond in sexual offenses, because in their circumstance, although it was a sexual offense, they did not maybe show that they could threaten the witness. They were not a flight risk, the general terms. So that's, I just wanted to highlight that part, that it shouldn't generalize that you can't get bond in a sexual offense. That's just the correction that I wanted to hear explanation so that I can correct on that part.
Thank you. Thank you so much, McKenna, for that correction. Indeed, I agree with you, because I was like, maybe I have forgotten, but you see, now I think from the explanation, yeah, she has done really well. Maybe Anyona, let us hear what Senior Honorable Odur Daniel will say, such that I can now come to you. Daniel, please unmute.
Hi, Angelo.
Hi.
Thank you. So this is what I think. I think I want to associate myself with the comments that have been made by Gitari, and I think this is a question that we talked about for a long time during our period. We have the right to bail now. In the new dispensation in the 2010 Constitution, all the offenses available. I think that's why we have to start from. It doesn't matter what you did, where, what, with who. All the offenses available. That's what the Constitution says. You have the right, an arrested person has the right to bail. Of course, this includes bond. However, what matters is the circumstances. I mean, the right to bail and bond is not an absolute right, meaning it can be limited in certain circumstances. However, the background is this: all offenses available. What really matters are the circumstances. So in the new dispensation, we don't have, if you talk about sexual offenses, then no, those ones you can't get bail. If you talk about rape, you can't. If you talk about murder, you can't. All offenses available. What will help you or what will make you get bail or not get bail are the circumstances. If those circumstances are enough to limit your right to bail, since the right to bail is not an absolute right, then you won't get bail. So again, I think it's very important for us to be very careful when we're answering that question. All offenses are available, just that the circumstances are what differs. Again, by saying that all offenses are available, are available, it doesn't mean that you'll always get bail every time and whenever you need it. It's not an absolute right. So then the circumstances will matter, but all offenses are available. There are no types and characteristics of offenses that now we are saying are not bailable. All of them are bailable. It's the circumstances that differ. Why? Because the right is a right that can be limited.
Thank you, Odur. Thank you for that guidance. Maybe Anyona, in less than 1 minute, maybe you can unmute and proceed.
Yes, I'll take less than 1 minute. So I'd like to agree with my senior Odur in total, and just to add some small bit that what my sister Cynthia suggests would make an accused person be denied the right to bail would not go to the type of offense that they have committed, but it will go to the consideration of interference with witnesses. So if the court is satisfied that this accused person who has been accused of defiling, say, their daughter, if they're going to be released to go out there, they're going to exert some influence on their daughter so that she may not give evidence in court, then that right may be denied, the right to bail. So there's authority on that. There's the case of K versus R. So in that case, I think bail was issued earlier, and then the same was challenged on the basis of interference. And the court was indeed satisfied that there was a likelihood of interference of the witness, who was a daughter of the accused person, and therefore bail was suspended. So that's what I have to contribute on that. Thank you, Senior.
All right. Thank you so much, Oscar, for that contribution. I will have nothing more to add. Safe to say, maybe you can download the authority and maybe send it to our group for our further consideration. So having said that, I'm now going to direct Honorable Cosmos to maybe scroll to question number 4. And maybe we'll read question number 4. We'll appreciate question number 4. And thereafter, we'll try to answer question number 4. Not my favorite. I like it that it did not come in my exam. But I can assure you 80%, or let me go down to maybe 70%, it might be in your examination this year. So, and maybe you look out, or maybe some of the things that are happening around the country. So maybe please scroll, Honorable Cosmos.
Actually there, don't know if you can see it.
Okay, no, I can see it, but you are just there at count 1. Maybe you can just scroll further, such that someone can take us through question number 4. Yes. All right. So we have someone called, who wants to read for us question number 4? Faster. Time is not on our side. We are now at 22:09. And we are still left with 2 more questions. Okay, 3 because we have not done question 4. Yes, Julia?
Okay, question 4. Bakari Sakari was charged alongside Raja Aslan before the Chief Magistrate Court at Milimani. For Bakari Sakari, he was charged with defiling a 13-year-old girl. The charge read thus: Count 1, defilement contrary to Section 8.1 as read with 8.3 of the Sexual Offences Act. The particulars are: Bakaya Sakari, on 10th day of January 2021, at Kahuna village in Nairobi County, intentionally caused your male organ to penetrate the vagina of BW, a child aged 13 years. Count 2, in the alternative to Count 1, indecent act contrary to Section 11.1 of the Sexual Offences Act. Particulars: Bakayo Sakari, on 10th January 2020 at Gituma village in Nairobi County, unlawfully and indecently touched the vagina of BGT, a girl aged 10 years, using your penis. Count 3, creating disturbance contrary to Section 95.1b of the Explosives Act. Particulars: Bakaya Sakari, Ruja Aslan, on 4th October 2020 at Ganjoni area in Mombasa County, created disturbance and caused a breach of peace by jointly robbing Rudido Denzel, a citizen of Kazakhstan, 2 mobile phones worth 75,000. Bakari Sakari and Raja Aslan retained you to defend them over what they term as trumped-up charges. With aid of decided cases and statutory provisions, advise your clients on the legality of the charges, appropriate strategies and interventions you would employ to defend them, while anticipating possible responses by the prosecution counsel to yours. 10 marks.
Very good. Thank you. Thank you for that, for your contribution and reading the question. Maybe Daniel, are you there? Are you still there?
Yes, I'm present. What's up?
Yes, maybe you can take point on this question.
Yes, but as usual, we'd like to hear suggestions from the team.
Yes, including
Yeah.
that. Yeah.
Yes.
Yeah, I can see Julia's hand is up. Maybe you can take it from there.
Okay, I'll give it a shot. For this particular question, the issues are the counts. To be precise, the gender of counts, where suppose the illegality relates to how the counts have been joined. And from my reading, we can see that count 1 happened on 10th January 2021 in Nairobi County, Kahuna village. Count 2 took place in Gituma village on 10th January 2020. So it's not the same year. And it's a different village, also Nairobi County. And count 3, we have Raja Aslan. This is now gender of a person on 4th October 2020 in Mombasa County. And my understanding of gender of count, let me start with gender of count first, is that for you to have gender of counts, charging a number of offenses together, they ought to be founded on the same facts or form a part of series of offenses of the same or similar character. In our case, let me use the example of, let's say you had stolen, then after stealing, there is now the stealing, there is retaining the stolen goods, then there is being found in a possession. Like for stealing, when such series, like a series that are connected to the first offense, you can join the counts. They need to like flow. But in our case, even from the facts that we've been given, the offenses occurred in different years at different places. So we have misjoinder of counts. As for joinder of persons, they also ought to, I feel like the count 3 should have been an entire case, like an entire charge sheet on its own. It shouldn't have been included even with these two. Here we're supposed even to have 3 charge sheets. The first count, it's different because it happened completely in a different year. There is the second one, a different charge sheet. And now since Raja Aslon wasn't there when the first 2 counts were taking place, he shouldn't have to be joined to the first 2. So yes, so we have misgender of counts and we have misgender of a person by virtue of Raja Aslan. Okay, I'll just go ahead and give a remedy, then another person can give their view. As for my appropriate strategy, I will seek for these charges to be quashed because of that misgender of counts. Yes.
Angelo, you're expecting to proceed, yeah, from there?
Yes, I did.
Okay. Thank you so much for those observations. I think they're quite important, and I think at this point we can see the type of charge sheet that we are dealing with. So thank you. I think that was very accurate and quite important in answering this question. Now going to the next person, what can you observe and what do you think? Anyone else? Yes, Derek.
Good afternoon, Senior. I think I've just noted one thing. At count 3, there's an issue of defective charge sheet. Since you've been told creating disturbance contrary to section 95(1)(b) of the Explosives Act, I think it's supposed to be in penal code. So I'm seeing an issue of a defective charge sheet. So maybe I can quote section 134 of the penal code.
All right. Thank you. Someone else, and even as you answer the question, let's remember again. Thank you so much for that. Thank you so much for even identifying that. So of course they have quoted the wrong section of the law. Yeah, and we all know for us to have an offense, you must have quoted the right section of the law. You can't just come up with things from nowhere. Thank you so much for that. Again, they're saying, with aid of the decided cases and statutory provisions, advise your client on the legality of the charges, appropriate strategies and intervention could employ to defend them, while anticipating possible responses by the prosecution counsel. So right now, we've made observations, okay? We are seeing where problems are. Is there anyone, again, who have made any other observation that maybe we've left out? You can just raise up your hand, then we can see. Yes, Samuel?
Okay, I as well think that under count 3, there could be duplicity in the sense that when we look at the statement of the offense, creating disturbance contrary to section 9(1)(b) of the Explosives Act, then when we look at the particulars, they say that those 2 persons on the 4th of October 2020 at Gajoni in Mombasa created disturbance and caused a breach of peace by jointly robbing Rudido Denzel. So I think there's duplicity in the fact that in the statement of the offense, they have not stated how the disturbance was done. It is not specific, so it's hard for the accused person to tell what was the exact offense that they committed. So there's duplicity in the statement of the offense.
Thank you. Duplicity. And the charge is duplicitous. Thank you. Any other observation that we can make? The three people who have spoken, please just be on standby. I'll just need you to, pin your answers to one thing. Is it duplicitous? Is it what makes it defective, or why do you have such an idea or such an answer? Well, for the last person, I think it's very clear. You've said the charge sheet is duplicitous because of what you've explained. Then I think someone also talked about misjoinder. We don't have I think the first speaker. We don't have the same. We have offenses happening in different timelines. Some are not even related, yet we have them in the same charge sheet. Is there any other person who'd like to say something that they've observed? Okay, we don't have anyone else. Now, I'm just going to give you a few case laws, even as we move forward. So, misjoinder of counts. When you're talking about joinder of counts, we need to look at section 135(1) of the CPC. It directs on how that should be done. Okay. If you look at the case of Muero versus Republic, Muero, M-W-E-R-O versus Republic. This is a case where, the counts were different, or the offenses were different, and there was the same charge sheet. And of course, we know what the court said. It was a misjoinder. I hope we've captured that correctly. Then we've talked about duplicity. So any count that charges within it more than one specific offense is said to be bad for duplicity. And of course, as we all know, that if the charge sheet is duplicitous, then it cannot be cured by anything else. In fact, it has to be thrown out. The case has to be thrown out. Why? It denies the accused person the right to be able to prepare themselves, appropriately. Which offense are they supposed to defend themselves from? I mean, what are we talking about? So of course, there we have Article 52B of the Constitution of Kenya. And of course, we can also talk about Article 25 of the Constitution. The right to a fair trial. Trial is an absolute right. I mean, it cannot be limited in any way whatsoever. So you come for me with one case. You can't come for me with several cases. For what reason? Then we can talk about the case of Republic versus Kauta, although it's a 1933 case. However, that case was on murder, and in that case, we had two separate counts of murder being put in the same charge sheet, and the court held that this ought to have been dealt with separately. And of course, the case was thrown out because the charge was duplicitous. Again, if you have time, you can also look at Republic versus Mongelia, if you have time. Then lastly, I'd like us to talk about overloaded charges. Overloaded charges. I think as we the way we've gone through the charge sheet and the counts. We have so many charges. So what do I mean? What do you mean when you talk about an overloaded charge sheet? So a charge is said to be overloaded when several counts are brought against an accused person involving different aspects of the criminal law. So as you realize here, we have someone, disturbance and which is contrary to section 95(1)(b), which of course does not even exist. Then we have rape. Then I don't know. We have another one. We have another one. So again, someone would argue that is those are overloaded charges. So this is where you have several counts just to embarrass or prejudice the person who you are bringing before court. Again, it's not in the interest of the court to waste time or to have anyone embarrassed. So even though in the case of Peter Ochieng versus Republic, it was stated that there should be no more than 12 counts on the same charge, I still think that it would be proper to consider that to that extent, since we have several cases from several parts of the criminal law. Lastly, and I think this is the fifth one, and I think when they were coming up with this test, they ensured that they capture almost everything. We have a defective charge. So this is an objection to a charge by reason of a formal defect on the face thereof, and this shall always be taken immediately after the charge has been read over to the accused person and not later. So in the case of Alwi versus Republic, it was stated that a mere technical defect in the charge sheet, which is not fundamental and does not cause a failure of justice, is curable. But if that is not the case, then it's not curable. Of course, if it is, when I say it's curable, it means that, you know, we can have it amended. And here we can also consider Article 159 2D of the Constitution of Kenya that talks about technicality. We focus on substance and not technicality. Again, I hope you know where to put this, and the reason as to why this can, you know, it can work two ways. So formality, meaning we talked about the Explosives Act, it should be there, you know, that should be amended, or why did they have it there? It means that it's wrong, so we have a defective charge. Okay. So let's just have that in mind even as we continue. So with the aid of decided cases, I've given you so many cases, statutory provisions we talked about a lot. Advise your client on the legality of the charges, appropriate strategies and intervention you would employ to defend them while anticipating possible response. So I'd just like us to also talk about the appropriate strategies and intervention that you would employ. Anyone? Now that this is the case, this is what we have. What would you suggest an appropriate strategies to, you know, to employ and to intervene in this particular case? Anyone? What would you do if this case was brought in your chambers? Now that this is what we have, then now we'll go to the last part of the question. What would you anticipate even as you come up with that particular strategy? Anyone? And if there's anything I've left out again, you can also talk about it. Now that this is the case, what would you use? What would you say and why? What would be your strategy? Or what would you advise as the strategies in this particular matter? Anyone? Meaning, where would you want this case to end up in? Would you want it to end up, do you want it quashed? Would you want it to proceed with an amendment? What would be your suggestion and why? Anyone? Guys, please, again, don't be shy, don't be worried. When you speak, you learn, especially when you're wrong. That's why it's very important to speak. So just tell me your mind. What would you do? Now that this is what we have, what would you do? Angelo, you can hear me, yeah?
Yes, Daniel, I can hear you.
Oh, so then I'm not alone in this meeting.
Yeah, definitely alone.
Gitari, I know you know. Okay, so anyone? I was just giving you those cases and statutory provisions as something to back up your answer. So anyone, what would be your strategy? Now that we have all those problems, we have all those mistakes, and of course we've seen what is curable and what is not curable. What would you go for? All right. So I know you can either go for one or the other. It's either you want this, you know, this charge to be quashed and move to you know, and have the case thrown out, or you can, you know, ask for an amendment of the charges. I mean, if that's what you want, I mean, I'd go for the most extreme part and just, you know, have it quashed. I mean, most of us would. And as you think of that, or if you'd go for that, you would have to remember this, that a charge does not, if a charge does not state and cannot by amendment be made to state an offense of which the accused has had notice, it shall be quashed either on a motion made before the accused pleads or on a motion made in an arrest of judgment. So it has to be that this particular charge cannot be amended. Now, we talked about 95(1)(b) of the Explosives Act, and we said, of course, that would be easily amended. And I think that's something that we can expect from the other side. That's something that we say, okay, fine, we captured it wrongly, we can amend it. But now, what about the other ones that we've talked about? Now that we have all the other ones there, so for me, I'd push for quashing. I'd push that this is not amendable. Even if we amend one part, we amend count 3, we still have so many other counts, and this is so confusing. Under Article 50 of the Constitution, this person has the right to fair trial. Under Article 25 of the Constitution, this right is an absolute right that cannot be limited by any way whatsoever. And so, of course, for me, I'd move the court to quash this case and, have life move on. Anyone else who disagrees with me, or anyone else who would prefer another strategy, and why? Please go ahead. Of course, I know we can't all think the same way. And as Angelo said, in law, every answer is okay so long as you can defend it. Anyone? Anyone? Guys, what? No one is raising up their hand. Anyone? Please don't be afraid. What do you think if this was CLE and you had this question today, what would you do? By the way, you can disagree with me totally. I have no problem. What would you do? Okay, Angelo, that would be it for me. I don't know what you think.
That is all on my end here, because I believe it has been covered well and you have guided us appropriately. So I would just maybe tell our maybe request our very own Cosmos to maybe scroll to question number 5, because time is also not on our end. It is now 22:31 and we have 2 more questions. Hopefully members will also participate in this in answering or maybe tackling these questions. Okay, so Enoch Adrian, please read for us question 5.
Question 5. Takiwa Lavito was charged with the offense of robbery with violence contrary to section 296(2) of the Penal Code. He underwent the entire trial process and was eventually convicted of the offense and sentenced to 20 years imprisonment. During the trial process, he noted the following. He was not present during some of the hearing sessions, which nonetheless proceeded. For his own preparation for trial, Takiwa was not supplied with some of the evidence produced in court, which the prosecution relied on. Some of the witnesses who testified were never sworn in before adducing their respective testimonies. The court failed to conduct a voir dire examination on minor witnesses. Part of the trial was conducted in a local dialect which he did not understand. Upon sentencing, he applied for bail pending appeal, which was declined. He has now approached you to represent him in the appeal proceeding. Draft the required appeal documents. Explain the circumstances under which bail pending appeal may be denied.
Okay, thank you so much. This is another good question. Maybe before we proceed, I would like maybe someone to just tell us whether the Chief Magistrate has jurisdiction to hear this matter, such that we don't belabor much on that point, such that we can know what is the appropriate appeal document to file. A very simple one. So who can tell us, does the Chief Magistrate Court has jurisdiction to hear matters that is relating to robbery with violence? A quick one. Annalise Kidding. Chirchir Annalise, you have something to say? So that we can save on time if we know where the court is. In this question, maybe scroll up. Have we been shown or maybe told where the matter was filed? Yeah, he was just charged. Does the chief magistrate have jurisdiction, or is it High Court? This is not a trick question, because if we don't know the jurisdiction, then we will not be able to draft or maybe prepare the appropriate appeal in this matter.
The chief magistrate does not have jurisdiction.
Does not or does?
Not.
Does not. Okay. Evans Ocheng?
Good evening.
Yes, good evening.
The chief magistrate has jurisdiction to hear and determine robbery offenses.
Okay.
Yes.
You have lost me again. You have said robbery offenses. You know there are several. Okay, a few.
Yeah, maybe. And even recently, I think there's a High Court decision which determined that chief magistrates can also hear murder cases. So they do not need to begin at the High Court, because that basically denies an accused person several stages of appeal. Yeah.
Okay, thank you. But when you say robbery offenses, what do you mean?
There's a robbery with violence and robbery itself. The only two.
What? Robbery?
Robbery under section 296, I think 2.
Thank you. Yeah, those are two different offenses, and they are distinct from each other, okay? So when you are talking about robbery, it is robbery. When you are talking about robbery with violence, then it is, okay? Anyona, did you have anything different to say?
Not quite. Just to state that indeed magistrate courts have jurisdiction to determine matters of robbery with violence under 296(2).
Okay, I believe when you say magistrate, you mean chief magistrate.
Yes.
Okay, thank you. So now that we know that Odur Donna, that is the position, so the chief magistrate can hear and determine matters or maybe cases relating to robbery with violence, okay? So now what is then the relevant appeal document that we can draft for these 7 months? Quickly, that is equally, it is not a trick question. Guys, time is not on our side, please. What is the document? The appropriate appeal document? Put your hand up, please. Daniel, maybe you can confirm. I don't know if I'm being heard.
Yes, we can hear you. I don't know why today people are so laid back. Guys, let's just be a bit active and just give our answers, please, so that we're also able to move. Just say what you think. Again, sometimes that's how we learn. Please, just say what you think, really. Donna, what do you think?
I think it is a petition of appeal, since it is a appeal from the magistrate to the High Court.
Okay, thank you for that. The reason I was saying it wasn't a trick question is because, you see, for criminal matters, it is different from civil matters in the sense that maybe in civil litigation, you will file a memorandum of appeal, okay? But for criminal litigation or criminal matters, from the chief magistrate court, from the magistrate's court to the High Court, will file a petition of appeal. Okay. Thereafter, from High Court to the Court of Appeal, you will file a memorandum of appeal, and the same will apply if you are to, for any reason, when I'm saying for any reason, that you will have an appeal from the Court of Appeal to the Supreme Court. You will also, you will file a petition. Odur, I know litigation is not your cup of tea, but it is a petition, right? You file a petition at the Supreme Court, right?
Yes, I want to believe so. But it's Gitari's cup of tea. What does she think?
Gitari, it is said that this is your cup of tea. For any reason, if you want to appeal, maybe a criminal.
Litigation is my cup of tea, but mostly civil litigation. But anyways, yeah, it is a petition of appeal. But that being said, civil litigation is my cup of tea. But anyways, it is a petition of appeal.
Yeah, so you will file a petition. It is a petition of appeal. Okay. So here we are filing a petition of appeal. It is a simple document. The content will still be the same as that one of the memorandum of appeal. Okay. There's nothing different here. So now maybe someone can maybe try to maybe draft for us something. We have already been given reasons there. Yes, Daniel.
I'm just wondering, in this petition of appeal, are we going to appeal on matters law only, or we can appeal on matters fact as well as law? I'd like one of the students maybe to answer that, even as we proceed.
A very good question indeed. Are we appealing on the matters of facts or both? Okay. Yes, Julia Atieno.
I think it's both, since this is the first appeal that we are making, so it will be both the matter of fact and law. If it were the second appeal, it will just be on the issue of law. Since it's the first appeal, both law and facts. Yeah, both.
Thank you. Thank you for that answer.
Okay.
You want to correct yourself? I have jammed the gun. Maybe you have to control me now, Daniel. Maybe Julia wanted to.
No, it's okay.
Can her answer? Yes. Thank you. That is the position. Never doubt yourself. Okay. Now, having any other, Daniel, that you would like, maybe we can look at in the meantime. Any other, or maybe someone try to maybe draft for us something, considering now maybe you are appealing against both issues of fact and law.
Yeah. Another thing just to add is that we also have to accompany our petition of appeal with the judgment. We have to file it. We have to accompany it with the copy of the judgment. Yeah.
So now who can maybe try to maybe draft for us something? We have been given everything that we need there.
Angelo, I think for purposes of time, it would be very hard for drafting virtually. I think even to also keep the students on toes, the drafting is, I think it would be best if they did draft at their own time, just to save on time. That's my suggestion.
Thank you. Thank you for that suggestion, Gitari. Yes, that is it. By the end, for good practice, this could be like free 7 marks. Please, you can attempt. Yes, Daniel, your hand is up.
Yeah, that's fine. And I agree with Gitari. But yeah, what are the issues, Angela? Maybe we can just look at the issues. What are the issues? Why would we be drafting this particular petition of appeal? What are the issues that we'd raise? Maybe just that.
All right. Yes, that is the question. I'm not going to ask it again. Guys, what are these issues that we raise maybe in this petition of ours, in this petition of appeal? Guys, there are 37 of us in the forum. Yes, Oscar.
Well, thank you. I may just state a few and let my colleagues proceed. Now, the first issue would be, I would start from the last information that we've been given, that the part of the trial was conducted in a local dialect, which he did not understand. And we know the Constitution under Article 50 states that the proceedings must be conducted in a language that the accused person understands. So there's a violation of the rights of the accused person. So that's the first issue. Then the second one that I pick from those facts is the fact that he was not supplied with some of the evidence produced in court, which the prosecution relied on. So the authorities that provide that the prosecution has a duty of disclosure, and they must disclose the evidence that they have relied on to the accused person so that they know what they're being charged with. So the authorities are the case of Patrick Cholmondeley versus Republic, a decision of 2008 that was so passionate about the duty of disclosure on the part of the prosecution. Another case that really also talked about that duty is the case of Republic versus Nduvi Mbuvi. So those are the issues that I can pick from the facts.
Okay, thank you for that, Oscar. So I would assume that if you were to write, let's say one, let me pick maybe the last one, but I hope in the exam you will not start with the last one. You will say something maybe that the learners magistrate maybe add in law and fact for maybe allowing the trial be conducted in a local dialect, which he did not understand, or something to that effect. Evans, take it away.
Okay, Oscar, maybe the first ground is usually and fact by entering a sentence that was not supported by the facts. Then the grounds which are being listed there will actually form the rest of the grounds. Yeah.
Okay, thank you for that contribution. I believe we will now move to our last question, because maybe Daniel will want to say one thing or two as we complete, because maybe our last session is around the corner. Maybe you would want to address something to that effect. Maybe in under 5 minutes or maybe under 10 minutes, we can finish question number 6. The reason I'm skipping, sorry, si ati kuruka, jumping, kuruka, but question number 5B is because it is something that we have tackled before, but now we are talking about bail pending appeal. Okay, what are these circumstances under which bail pending appeal may be denied? And guys, these are always the free marks. And I would advise, if you see something like this in an exam, please just go for it. Okay, we will talk about that maybe in a few. Maybe someone, Gitari, maybe you can read for us question number 6. Chief litigator.
Okay, question 6. Chumu is a businessman within the county of Kajiado. He is a dealer in livestock, cattle, and goats. Trade and frequents Kajiado, Ngong, Kiserian, and Kitengela abettors and animal actions to conduct his business. Sometime in December 2018, there were numerous animal thefts in Kajiado, Kiserian, Kitengela, and Ngong areas, where the owners lost over 1,000 animals. Since Tumu deals in livestock sales in large numbers, He was suspected to have been involved in the crime either directly or indirectly. Even though all the raids in the above areas occurred at night, the security guards employed by the owners of the livestock stated that they had seen the raiders but would not be able to recognize them since it was dark. During one of the animal actions at Kajiado town, Tumu was arrested and held at the local police station. The guards were summoned by the investigating officer to write witness statements, which they did. The investigating officer has informed the complainants, owners of the stolen animals, that the investigators have searched the home and spoken to the relatives of Tumu, but they did not find any livestock resembling any of the reported stolen animals. All Tumu animals have pierced ears and have round necks, which the stolen animals did not have. Nevertheless, the owners have rigorously insisted that Tumu was involved in the theft. The investigating officer has now informed Tumu that the guards and the owners insist that he is a suspect and will be able to positively identify him as being among the suspected livestock thieves. Tumu, having seen the seriousness of this issue, has engaged you for advice and to represent him throughout the entire trial process should the need arise. In order for you to proceed, however, he must be satisfied that as an advocate you have at the tip of your fingers the necessary legal acumen to represent him. Tumu is apprehensive that the investigating officer will conduct an identification parade before taking him for plea in court. In light of the above and with the aid of relevant case law and statutory provisions, critically evaluate and advise him on the rules governing identification parade as related to his present situation. 10 marks.
Okay, thank you so much, Gitari. Now, this is also another good marks. Okay, and I don't know, Gitari, you can guide us on this question. And maybe Odor will come in after you, maybe towards the end.
Okay, okay. So guys, what I think there are various case laws on identification parade. Clearly, you can see that this question is just examining on identification parade. So I would want your participation. Is there any hand up?
There is none on my end.
Okay. Any question, anyone who has not understood the question that's before us, maybe that's what's yes, Donna.
Okay, just a contribution to the question. The rules of conducting an ID parade were set out in the case of Republic versus Mwango, and as concerns this case, maybe one of the rule that is applicable is that the witnesses, now in this case the guards, need to have identified him positively, and in this case there's the issue of light and maybe distance. Okay, I can't see the question hapo juu, but there was something about it was at night and it was dark. They were not able to see the people who took the cattle. So that's one rule that will apply. And in that case, an ID parade should not be conducted when they can't identify the physical physical characteristics of the suspect. Yeah.
Thank you so much, even for identifying the case. So Donna talks about positively identifying someone, about the lights and about how it was dark. Thank you. Anyone else? Yes, Derek.
Well, I'm seeing a scenario here where the investigating officer. Hold on. Okay, the guards somewhere this is on the last paragraph. We're being told that the guards were summoned by the investigating officer to write witness statements, which they did. And picking up from where Donna left on the case of R. Mwango, I think the investigating officer should not be in charge of the parade or something of the sort.
Yeah, thank you. That's also another rule when it comes to identification parade. Now I'm wondering whether I'm supposed to be okay. Yes, there's Donna.
Okay, another scenario another rule that arises from this case is that they knew Tumu, and as such, identification parade is not necessary. It's not supposed to be conducted where the witnesses know the suspect or the suspect personally.
Yes, that's also another factor. There's a book I've shared in the group, and I've particularly shared it because I have realized I don't know, maybe it's people have an indifference when it comes to criminal litigation, but today you people have been weirdly awfully quiet. So I do guide when I feel like maybe people are not understanding something, but I feel this is not about not understanding. It's just that you have not read in depth. So Daniel, on my part, I will put it back to them to go back and just study. It's when you do revision and you get to see some topics and you see this is a particular part where I have not, like brushed up. It's good that you go read about the identification parade and understand. Then maybe where you're not understanding, that's where we can come in. But Daniel, I don't know if you can take it over from here, because on my part, I don't know. I have I don't say I have nothing, but I don't know how to proceed.
All right. Thank you. Thank you so much, Gitari. Yes, I can take it up from here. Guys, now, as I take it up, today I want to be a storyteller. I want to tell you a story. When we joined KSL, during our year when we joined KSL, the rumors around were that criminal litigation was very hard. Oh my God. Everyone would tell you from the gate to every office you'd go to that criminal litigation was very hard, very hard. In fact, this was because of the class that had done their exam just before we joined KSL, and people had failed terribly in criminal litigation. So it was a perspective. You see, the same way you go to university and you're told, for those who went to UON, that PIL is so hard. PIL is so hard. You'll get FDP and you will never pass it. And you are faced with two options. It's either you believe it or you conquer it. For us, we were told that criminal litigation was very hard. In fact, if we were reading conveyancing twice, we were supposed to read it 6 times. And I remember when I joined, I had that particular perspective. In fact, I used to just pray that, God, please, I'm okay with everything else, but just help me pass. I don't care even if I get a 50, I don't care. I just want 50 and above. And we used to be in class, and I think it was Gitari was the star of those classes. She'd answer all the questions and we'd wonder and say, what? This girl is so brilliant. Something so hard. How could she understand it? That was my perspective until I read the book that Gitari has just sent to the group. Guys, that book is very easy to understand. That book is captivating, and that book is very resourceful. It will change your perspective totally when it comes to criminal litigation. At KSL, I remember during the first period, I'd tell anyone, you can ask me any question, but don't ask me anything on criminal litigation because I'll disappoint you. I'd go to a place where people are discussing criminal litigation and I didn't want even to be there because I knew nothing. I'd hear, I deparate, what is that? I have no notes. I mean, if you go through those classes, sometimes there's nothing. There are no notes. There are no notes apart from, I think there's a lecturer who used to teach us and used to give us so many notes. Guys, the book that has been shared with you in the group, just read it. If you're feeling like me when I just joined KSL, this one is going to change everything. We've been giving answers here, and you hear people saying, I think this is the answer. When you read this book, you will not have I think. In fact, you'll have so many answers until you don't even know where to put what. So this is just to encourage you guys. Criminal litigation is not hard. Guys, it is not. It is easy. And I don't apologize saying this. It is easy. Sometimes we just need to push ourselves. And so I'd like to encourage us. Now that exams are coming up, guys, just take your time. I'm telling you, this book is so interesting. You can even read it in the matatu on your way home, and you will just understand it. The way Justice Kiage has tried his best to explain everything, and the way everything is just, like in line, it will make so much sense. After this, we have this. After this, and he has taken his time to explain it to the extent that even someone in primary school would understand that particular book. So I know Gitari has shared it in the group. Just take your time. Guys, you will meet me. I will meet you. One day we will talk and you'll say that book really changed my perspective when it comes to. You'll find case law there. You'll find statutory provisions there. It's so updated. Everything is so clear. It's all you need if you ask me, right? Especially if you're struggling with criminal litigation and exams are coming and you're panicking. Please just take your time and read that book, and everything is going to change. Again, perspective really matters. Guys, criminal litigation is not hard. In fact, nothing is hard. Sometimes we just need to read and everything is going to be okay. So again, just to reiterate, just to emphasize, please just take your time and read that book. And I know that you'll do well. For our year, I think this book was circulated so many times. And I think, man, I don't think there's anyone who failed. We had 90s, 92, 96, 98, 95, 94, 90. If you'd ask your friend, what did you get? 96. I'm sure I'd ask Gitari what she got, and probably she'd say, I don't know, 97 or 98 or 96 or 95, somewhere out there. But I'm sure it's above 90. This book really helped us. When I read it, now I'd argue with Gitari as if, this is a whole new person. So if it's perspective, let's change it. Whatever it is, let's change it. Please read that book and you will be okay. I think this is the first discussion I have joined, and guys are just so cold. Everyone is just so down. And I don't know, maybe it's about exams, that the fact that exams are coming up and you're scared to give an answer. I mean, if you can give a wrong answer now, are you really ready for exams? Please, guys, there is still time. There is still time. And CLE is an exam that you can do and pass. Whatever it is, you can do it and you can pass it. There's still time. Learn whatever you can learn now, and it will help you. Again, me, Angelo, Gitari, we are all at your disposal. Just send a text, call. Of course, if you call, sometimes we can't pick up, but send a text and we'll be able to we will be able to talk to you. Please, please, please. Let's leave no stone unturned. Let's ensure that we are ready for these exams, and as we are ready to help. Now, criminal litigation, you have the book that Gitari has shared. Please read it. You will go through that book, and when you finish, you'll go through this question, this paper, and you'll just be laughing to yourself, like, what is this? This is so easy. How they set this? And stuff like that. Angelo, that's all I can say. I don't know if you have anything to say.
Yes, thank you, Daniel. I don't have much to say. Safe to add that, guys, this thing is doable. What I'm about to say, it is not for any other purpose, but to maybe encourage you, especially for those who feel like the pressure is really, really getting worse. And maybe you think maybe you want to maybe just, let's say, suspend or maybe adjourn or maybe stay doing some of the exams. It is doable. Okay, for me, I started my pupillage before doing CLE exam. I only read for CLE when I was now, let's say, when pupillage was suspended. Okay, because during pupillage I would come, I would say maybe I will read, but pupillage is not easy, especially when you are in a busy law firm. Okay, so it is work full time. Okay, when you come home, you are tired. So if you feel like you have not read, no, that is a lie. You have been reading for the whole year. At that time, I believe that I have been reading. Daniel and Gitari are prepared as you are ready for exam. I was attending this session here, these sessions like this one. Okay. So, and sometime maybe I went at one point or the other, I would say, you know what, Daniel, I got my 9 Ps. Okay. So what I'm trying to say is to encourage you guys that this thing is doable. Maybe we'll have our last session next weekend or maybe the week after, but we will discuss, but probably maybe it will be this coming weekend so that we can give you your time for you to maybe prepare for the exam. Okay, so it is doable. Criminal, I love it because it is easy to do. Okay, it just flow. I don't understand why. It is really, really easy, and I cannot apologize for that. Okay, save that now I'm into civil litigation. I don't do criminal, lakini ukishikwa unaweza nitafuta. But guys, please be motivated. These 2 weeks are very, very important. They are everything. Put your timetable in order, and one day, one time, maybe after 3 months, you will celebrate. Na utatuambia tu. Don't be discouraged if someone is pretending to have read. Unaweza toroka huyo mtu, okay? And focus on yourself, because someone is going to come with a lot of English here and there, and maybe you will feel discouraged that you have done nothing. No, you have read. No one is ever prepared for exam. If you are not scared right now to do that exam, you are lying to yourself, okay? But if you know that you are scared for that exam, it means that you are on the right path. So you will be totally prepared for the exam when you complete and finish that paper and put it aside. Even the exam period, some people do transnight. Okay, I will not advise that, but in one paper I slept for only 2 hours. Okay, it's still doable. Time is there, and it's just for you to go for it and take it and study. I don't know, Gitari, if you have maybe your last words as we are about to conclude.
All right. I think I can just encourage you people, because today obviously you can see we can all feel that you are down, but just as a way of encouraging you and telling you that the feeling that you're feeling, maybe at this point you are looking at this paper and you're feeling where, maybe you are looking at the paper and you're feeling, well, I don't know anything, and maybe you are feeling scared, but guess what, there is always time to recover. Best thing is when you identify your weakness, you can always put in more work towards it and just read hard and believe in yourself and study smart, by the way. At this time, it's not about how hard you work, it's about how smart you work. So, it's you worked hard the whole time you've been in KSL. At this time, it's now being smart in how you revise for your examinations. Obviously, you now seen various past papers, you've seen how CLEs test their papers. So now it's not like you don't know how they test, so how they examine. So it's up to you to look and study their trends and even anticipate for various things that might be questioned, and study and read and believe in yourself and also rest. It's very important, by the way. When I was preparing for my exam, someone told me about rest, and I was like, are you mad? There's no time for resting. I'm supposed to be studying but 24/7. But I realize it's good to just study, but also have a healthy break so that you don't blow your mind up. And don't be afraid. Some of these papers that when we did it, as Angelo says, no one is always fully prepared. When we were doing the exams, we were obviously nervous, but we aced it, and we aced it because we knew something about about anything. The trick about silly papers and how you can be able to pass is at least read. If you don't read, I will not lie to you. I will not sugarcoat it. If you don't read, it's going to be hard to pass CLE exams. But if you read, that small thing that you've read, it will boost you way, way, way so much. So read, be smart in how you answer your questions, and believe in yourselves, and relax. At some point, cheka kidogo, and you'll be fine. If there's any questions that you guys have during the course, be outside, during these sessions, you can always reach out to us. We'll be there to guide. But you see, even when you don't read, you can't even ask questions because you don't even have the content to ask. So my encouragement will be read, and you'll ace it. Don't feel so much pressure. Usijipatie pressure mingi. Hii mambo ni hakuna pressure. Usijipatie pressure. Ukijipatia pressure utajimaliza bure. Just read and you'll realize that it's just as simple as APS. You've seen some of the questions here about right to bail, very, very, very simple terms, and you'll just get your free 7 marks. Imagine. Yeah, so those that are the question that you might think are so hard, you'll just find that you're able to answer it. At least when you have content, you can even be able to persuade an examiner. This is law. It's how you argue. It's how you present your matters. You can even persuade the examiner and say, this person knows what he or she is talking about, and you get your marks. So yeah. So that's my advice. Yeah, even though I associate myself with the sentiments of Angelo and Daniel, and I wish you the very best in your exams.
Thank you, Gitari. Maybe I will finally maybe hand over the mic back to Daniel to pray. But I would also like to challenge you to look at the worst performed paper, maybe in all the 9. The keyword is the worst performed paper. I know you have looked at the best performed, but look at the worst performed paper. I can assure you for a fact that the people who are the worst performed, if you read those answers, you will definitely know that that person have not read. So for CLE, by the way, you have been attending classes, you have been revising, all the questions that will be said in that paper, you will know them. Donna, you have been here from the beginning, you have been participating. Same to Anyona, same to all of you. Even some people have disappeared because we used to be money. So guys, it can never get worse. It can only get better. So Daniel, maybe you can maybe conclude the word of prayer. You are our prayer warrior. Or there's someone, as you pray for us, there's someone called Atsango Derek. You can take his question quickly and you will answer the question and then proceed to pray for us. Thank you.
Okay.
No problem.
Angelo, mine is just a concern. As I don't know if our time is up, but we had left question 1 pending. I don't know, before we adjourn, if time allows, if you can just give us, even if it's pointers on how to go about it before we can adjourn, if time allows, kindly. We had left it pending, so.
Thank you for that question, Derek. What I will do is maybe it will be the first thing we'll do in our next session because most of our members have left the forum and maybe our time also is not on our side because now it is 23:15 and we were supposed to finish at 23:00 hours. So maybe if you may indulge me and maybe for the sake of our colleagues, we can maybe do it first thing next Saturday. Daniel, is that proposition okay?
Yeah, I think that's okay, Derek. But I think you can also just look for Angelo separately tomorrow when he has more energy and see what you can get.
Sure.
Yeah. Guys, we continue to commit ourselves to be a beacon of hope for you guys and to just be a pillar of hope for you guys. And I think one thing that I can say or just emphasize is that it's doable. It's doable. When you look at it, maybe sometimes it looks like a hill that you won't be able to climb up and come back down at the end of the day. But that is just how it looks. That's not really how it is. The way Gitari have said, the way Angelo have said, guys, you just need to read. One thing you just need to ensure that you are doing is reading. Just read. The way we usually say, and the way we've said from the beginning, the fact that now we are here means we are not stupid people. We are brilliant people, man. We are brilliant. We can do this, man. We are the future chief justices. We are the future attorney generals. We are the future senior counsels. We are the future judges and magistrates. We are it, and we can do it. We can do it. It takes time. Now, sometimes you might feel anxious. Fine, cool. I mean, sometimes they say, the most courageous people are not just courageous. They are those who fear, but they go past that fear that they have. They stand up, they take action, they move on despite what they are feeling. And so I'd just like to encourage us this night. Let us be like those people. Let's be courageous. That yes, maybe you might be feeling, anxious, but you'll do it anyway. I mean, if you don't do it, we'll do it, man. It's us who have to do it. We have to make it, and we can make it. It's not rocket science. We can do it. So just do your part. Just do your best. Just read, like you just read. Just do your part. Everything will fall into place. I'm telling you, your dreams will come into fruition. They will come into fruition. Just do your part. Just do your part. Just ensure that you're reading. You are so brilliant. You are too brilliant not to do your part. Just do your part and you will see the magic. Things will just work out. Again, you don't have to get 90. You don't have to get 100. You don't have to get 96. It's not a competition. Imagine when the results come out, you'll only see pass. They won't be like Donna, 99. Nyatichi, 98. I don't know who, 14. I don't know who, no. Everyone will just get a pass. And for you to get a pass, you need to get 50 and above. Now, the units that you are struggling in, just try and know something and know enough to take you to the next level. Know enough to take you past that 50. There's some that you know and you know everything. Learn how to balance, not to put so much of your time there. This is not the time that you're specializing. There's one thing that Gitari told me during our revisions. Again, this was in relation to criminal litigation. I used to tell her every time, I don't like criminal litigation. I just don't like it. In fact, I won't even practice it. But she told me that, but you have to get 9 Ps, man. You have to get 9 Ps. It doesn't matter what you like, what you don't like, what you hate, what you're going to practice, what is going to happen. I don't know where, whatever. So just put in the effort now. Get those 9 Ps. Everything you don't like, you can forget about them after that. But for now, just do your best. You are too brilliant. You are very brilliant. You just need to read and you'll see the magic. If there's anything you can remember from our discussion today, it's just the fact that you are very brilliant. You are too brilliant. You just need to read and you'll be able to pass your CAD exams. It's not rocket science. It is not rocket science. You are too brilliant. Don't waste it. Don't waste it. Don't allow yourself to waste that brilliance. You are the future. You're the future creme de la creme in this country. Don't waste it. Don't let anything make you waste it. Just sit down and do your part, and everything will fall into place. Everything will fall into place. Just do your part. Okay. So I'm going to finish with a word of prayer, and I hope that this session will help us and also just rejuvenate us and give us more energy, give us more courage. Despite the anxiety, we keep going. We keep going every day. We keep going. Despite whatever, we keep going, man. We keep going because we're the best. No one else is going to do it if we don't do it. We have to do it anyway, and we can do it because we are the best. Okay. Let's believe and pray. Father, what in heaven, Lord God, we thank you, we worship you, and we adore you, King Jesus Jehovah. We thank you for the spaces that you have put us in. We thank you for the plans that you have for us, for we believe and trust that they are only good plans. Lord, we thank you for the journey. We thank you so much for the process. We thank you for the memories that we are making. We thank you so much for the knowledge that we are getting. We thank you so much, oh God, my Father, never and Jehovah, for everything that we keep doing each and every day towards the CLE exams. We thank you for life. We thank you for your gift of breath. We thank you for peace that surpasses all human understanding. We thank you for health. We thank you for for giving us a sound mind. We thank you for everything, King Jesus, Lord. Lord, I surrender this group to you. There's nothing that you cannot do. There's nothing that you cannot change, King Jesus, oh God. How I wish that may they all pass their exams, all of them, that may they make history, that may this, Lord, be for the history books, King Jesus, oh God. Lord, may you hold their hands, may you give them wisdom, may you guide them and lead them. Lord, may you give them courage, may you give them courage, Lord, my Father. This evening we come against any anxiety. May you give this, Lord, courage. May you walk with them. May you lead them, King Jesus, Jehovah. Did you take over their minds? May you give them the right perspectives. May you give them wisdom and knowledge. May you give them the grace to read and to understand, King Jesus, Jehovah, Jireh, my Father. Lord, we come against any laziness. We come against any disappointment. We come against any discouragement. We come against any darkness. Lord, we call upon your light, oh God. We proclaim and we declare that we are winners. We proclaim and declare that, King of Kings, we are champions, oh Lord. We proclaim and declare that, Lord, my Father, we are the future judges and senior councils. We're the future creme de la creme of this nation, oh God. For your plans are only good. You are only associated with excellence, and nothing else, Lord, my Father. You are not a God of failure, but you are a God of excellence, Lord. I surrender these guys to you, God. Be with them, walk with them, oh God. That even as we go to sleep this night, oh God, my Father, may you give us peace. May we sleep well, oh God, my Father, never, oh God, my Father, King of Kings, may we have good dreams, King Jesus, my Father, but never. May you guide us, may you protect us, King Jesus, oh God, my Father. Lord, I worship you, I adore you, and I praise your name, and I surrender all before you, for it is in your mighty name that we pray and believe. Amen, guys. Have a blessed weekend. Amen.
Amen.
All right. See you guys.
See you.
Amen.
See you.
Thank you. See you.